Attorney Rice, I get an opportunity to speak this morning.
I have, Your Honor.
Complaints against you, sir, number 1048CR1756, alleged unarmed burglary, entering a home in the nighttime for felony and putting a person in fear, and vandalizing with noxious, filthy substance. These offenses are alleged to occur in the town of Air on December 16, 2010. I gave the judge the other case. I don't know if there's a protection request.
Does he qualify? I'm sure he does. Attorney, sir, you have a right to be represented by a lawyer on the new matter. Would you like me to appoint counsel, sir? You don't want a lawyer?
Well, I already have one.
Okay.
I asked to represent him only for purposes of the bail argument, Your Honor. He's already represented by Attorney Dan Murphy, and I think it's appropriate that Attorney Murphy...
We'll do that. We'll appoint Attorney Murphy. We'll have no contribution relative to that. We'll appoint Attorney Murphy. All right, why don't you plead not guilty on that matter? Comment, you looking for bail in the matter?
I guess, Your Honor, the counsel is moving to revoke the defendant's open case and is also requesting $7,500 cash bail on the new docket, Your Honor. He has an open intimidation and threatening out of Lowell District Court, Your Honor.
Okay, probation is also seeking detention.
Yeah.
All right, why don't I hear you on the revocation of bail?
Thank you, Your Honor. The Commonwealth is moving to revoke the defendant's bail based on the fact that the defendant has committed a new offense, and that new offense does place the community and specific individuals at risk, Your Honor, and at danger. Your Honor, the facts of the new case are as follows. On December 16th at approximately 11:30, officers of the Air Police Department were dispatched to 7 Calvin Street for a report of an unknown person in the house. An individual called and said she could hear an unknown person walking around the first floor of her house. While en route, she was on the 911 recorded line. She was speaking with dispatchers. She told dispatchers that the person had gone upstairs and was attempting to enter her bedroom. She had her and her daughter locked into the room. When officers arrived, they observed a white Toyota 4Runner parked outside. Officers approached the house. They entered the house. As they made their way up to the side door with their weapons drawn, they looked into the kitchen and saw an unidentified person wearing a dark clothing and a hood. Found out later to be Stephen Leonard, the defendant before you. He was standing in front of the open refrigerator. As they reached the side door, he looked out the window and saw us. Upon seeing the officers, he ran towards the back door and walked out of the door. Officers went around back. They pointed their weapons at him and ordered him to show his hands. They could see that Mr. Leonard had a flashlight in one of his hands. He at first began to step back into the house, and as he did, they ordered him to get down on the ground, which he did comply to. Officers secured Mr. Leonard. He told officers that he was staying at 3 Calvin Street, but was unable to gain access because the house was locked, that he didn't break into the house at 7 Calvin Street because the door was unlocked. Officers recovered several items belonging to Leonard. Officers continued to look through the house, spoke with the reporting party again. She stated that she could hear his voice as he walked around on the first floor. He went upstairs, attempted to enter her bedroom. She told him several times to go away. He responded by saying okay, but he did not leave right away, despite having contact with these individuals. He stated that after checking her house, She stated that after checking throughout her house, she noticed that her daughter's school bag had been emptied out and her laptop computer had been opened and moved. She stated that the door that was found unsecured was the back door leading out into the fenced backyard. Officers continued to speak with Leonard, who stated that he didn't break into the house. Your Honor, at booking, he was very combative with police officers. He was threatening to kill the officers or have them killed by other individuals. He was threatening to kill himself if he didn't get food. He also put some sort of substance on the camera, Your Honor, and was additionally combative and difficult with the officers, Your Honor. That would essentially be the facts with respect to the new case. The Commonwealth is also asking for $7,500 cash bail. This request is based both on the facts of the new case, the fact that he's charged with unarmed burglary, which is a Superior Court only charge. He does face significant penalties and indictment. Your Honor, if you look at his record, he's got other violent crimes on his record, threats, intimidation, other violations of restraining order. In addition, Your Honor, he is on probation in this court violated that probation with this new case, and the case that he's on probation for is a violation of a restraining order, which I would suggest goes to the defendant's ability to follow court orders, comply with probation, comply with restraining orders, and I would suggest you can consider all of that with respect to bail. Your Honor, in addition, the defendant has 2 open cases out of Lowell, which are both violent in nature. He has 4 other restraining orders out against him in the past. For all of those reasons, Your Honor, the Commonwealth is asking for $7,500 cash bail to hold the defendant.
Attorney Mahoney, have you been able to ascertain on the Lowell case that you seeking revocation of the bail, whether or not the bail warrants were given?
I have not, Your Honor. I would proceed under, I haven't had an opportunity to call Lowell this morning. I apologize. I can try to do that now, or ultimately I would just be proceeding under Commonwealth v. Tice, which presumes that bail warnings were given. In addition, Your Honor, I would suggest that from the defendant's record, he's very well familiar with the fact that of arraignments, of court orders, of bail warnings. So I suggest that you can look to his record to determine whether he knows that.
Thank you. Attorney Rice?
Your Honor, Mr. Leonard is residing at a home that is right next to the home involved in this matter. He's been staying there for 3 days with Delano Pringle, and I've confirmed with Mr. Pringle's sister today that indeed that Mr. Leonard lives there. Mr. Leonard tells me that when he entered the house, essentially, basically, he was making a mistake going in the wrong house. He at no time when he was found by the police, as he was leaving the house, there was absolutely no merchandise on him. It's hard for me to see how unarmed burglary is going to survive. I don't see anything in the police report about vandalizing the home at all. The homeowner was frightened, and that's understandable. And basically, Mr. Leonard walked into a home. He's only been there for 3 days. It was a long home. He takes Depakote. That medicine was not available to him when the night this occurred. He needs Depakote. The police have his prescription, and he has a place to stay. And he was arraigned on another matter here just several days ago, and received a pretrial date of 1/7. I'd ask that he be released on personal, to stay away from the residence, to stay away from the person involved in this, and he will be here on January 7th.
All right, thank you, Attorney Rice. I want to defer a decision on that. Can I give probation relative to the detention request?
Sure, can I have over probation? This is Maria Simone's case, and it's not here today. I'm covering, but he was just here on November 14th for a detention hearing. At that time, both the notices should be in the docket, but I just did new notice today based on the new charges that we just heard about. Also, we failed to report to Lowell probation, failed to pay a probation supervision fee, failed to verify outpatient treatment, failed to sign releases, and also the new charge of intimidating a witness on December 9, 2010. I can also tell you that I was downstairs in lockup, but he did threaten to kill me today. It was very, very violent down here, to the point where we couldn't even book in some of the people that were down there. So for that reason, we're asking that he be detained.
Attorney Rice, on the detention issue?
But I really don't think it adds anything, Your Honor. I mean, the violations other than this new matter are not the type of thing that you would detain someone for. I think at the bottom, you have to make a judgment as to whether or not this gentleman is in danger. He feels comfortable. If he gets his meds, that he'll be fine. He has a place to stay. And as I said, whoever was sitting here several days ago released him, he'd ask to be released again.
Just inquire as to this new case. It's not on the work probation report I received this morning. New case out of...
Case a couple days ago?
Yeah.
Lowell, 12-9.
Oh, it's Lowell. Okay.
Lowell.
Okay. So Attorney Rice was just saying out of here, so...
Okay. All right, thank you, counsel. All right, the Commonwealth's motion to revoke bail was allowed. I'm sending cash bail in the amount of $5,000 in the new case, and I'm ordering that his probation detention be detained pending a final violation of probation hearing. And we've appointed Attorney Murphy.
Please.
Thank you.
And I'd ask for a pretrial date of January 7th on the new matter. And on the probation.
I'm not on probation in Lowell, so she's wrong, because I got sent back here. You can call it
Frederick,
Frederick
Okay, 1-7.
Frederick Clark. Well, she's wrong, and I don't appreciate that. She doesn't know what she's talking about. Because if this is supposed to be truth and all that good jazz, why don't we get to it?
All right, we're all set. Thank you very much.
Oh, we're all set, well, I'm not all set.
Your help, the motion to revoke the bail on the Lowell case was allowed, and it's going to continue to January 7th for pre-trial and final hearing.
Your Honor, on several occasions, he's mentioned today suicide things. I think he should be on suicide watch.
Okay.
And just, I don't think there's a need to bring them out, but I just want to reserve my right to ask for a stay-away order if the case goes on beyond the revocation period.
You
Your
can do
Honor.
that.
Okay.
You can do that. We should note that, though. We'll let the court office. Thank you, Attorney West.